Akshay. Namaskar. We are delighted to inform that as part of Symbiosis Golden Jubilee celebrations, Symbiosis Law School NOIDA, in association with Lex Witness, India's first magazine on legal and corporate affairs, has organized a webinar series titled Knowledge Series on Law and Advocacy. Live 5 of the series is scheduled today on the topic Advocacy, Practical Aspects and the Psychology of Arguing Before a Judicial Forum by none other than our very own Mr. Percival Billimoria, Head of Chambers at Chambers of PS Billimoria and Senior Advocate, Supreme Court of India. It is an honor for me to introduce in brief Mr. Percy. Mr. Percy started his legal career with Arthur Anderson in 1987 and is also qualified as a chartered accountant. He was the national chair of the firm's disputes and litigation practice at Cyril Amarchand and had Delhi office till July 2018. Prior to that, as a senior partner at AZB and Partners, he chaired its litigation practice from New Delhi. Mr. Percy is known for his extensive expertise as an arguing counsel in adversarial matters, litigation and arbitration, pertaining to commercial transnational matters such as contracts, joint venture, and project finance matters, oil and gas, power and infrastructure contracts, antitrust and white-collar crime issues. Mr. Percy is listed in the Who's Who litigation guide, and Chambers and Partners recognizes him as being well known for his expertise in litigation in the areas of joint ventures, infrastructure projects, and project finance. He has also been recognized by Asia Pacific Legal 500 as one of the leading individuals in India and as a fine lawyer and a leading individual who comes highly recommended. Mr. Percy holds several positions of responsibility, including Honorary Overseas Member of the Commercial Bar Association, Non-Government Advisor to the Competition Commission of India, India Committee of the American Bar Association, Indian Council of Arbitration, empaneled as arbitrator with London Court of International Arbitration, Fellow of the Institute of Chartered Accountants of India, and member of the Bar Council of India. Before I request Mr. Percy to continue with his address of the day, I would like to explain the rules of housekeeping to the audience present here. Mr. Percy will deliver his talk and then at the end for half an hour, we'll take the questions. In the meanwhile, during the session, if you have any question, please write and put those questions into the Q&A box, which would be taken duly at the end of the talk. And the ones who would like to raise the live questions, an announcement would be made by Mr. Akshay, and accordingly, you will raise your hand and would be provided with an opportunity to raise live questions. Without much ado, I request Mr. Percy to deliver his talk of the day. Thank you very
much. Thank you, Doctor. Thank you for having me on a nice Friday afternoon. So this is a very fascinating subject because if you think about it, it's something where one might believe that it is just experience that matters. But then when I started to articulate this for a book that I'm writing, I realized that there are so many thoughts that come to mind, and it's necessary to organize some of this. And there are various sources behind these thoughts, but of course, experience is a very big factor here. So let me proceed with the topics, which is divided into 5. There were so many issues, I had to organize them into segments. So one is the pre-essentials, the rules of ethics, preparation, and the rules of argument when you actually set out your case before a judicial forum. And then the last one is understanding the judicial mind. So coming to the absolute pre-essentials, some of these are just thumb rules, but one of the main issues that I see debated today is dress. A lot of people say, well, in USA, judges do not dress very formally. Lawyers wear tie and suit just like any other businessman. I am a very unconventional person, but sometimes tradition is very good. And I think in these times of pandemic, we are seeing the wisdom or some of the old traditions that have been set out. There is a reason behind that. So I think the first aspect is proper dress. Proper dress. Of course, lawyers in India have a very prescribed dress code, but it's very necessary to be dressed in the best possible manner. It's more about how the dress makes you feel. It's a psychological impact, both on your own self to start with and on how others perceive you. Uh, Extremely important. You cannot be shabbily dressed. It has a huge impact on the dignity and bearing. And remember, as a counsel, this is what adds a lot of presence to who you are in court. There are other elements of presence of court. One very important aspect uh, of a counsel is voice. And of course, this is a uh, God-given attribute. A good voice, a good booming voice in court is very useful. Uh, but let me tell you, it is possible to train your voice. It is something that I am actually working on at this point. But I'll just say that Mrs. Margaret Thatcher actually trained her voice because it was very squeaky. And the perception was that the voters do not appreciate uh, an address by someone who's speaking in a squeaky voice. And she actually managed to train her voice. So that's another aspect that you have to pay attention to. And your demeanor, your entire demeanor in court has to be completely professional. Uh, None of the pretentious stuff. So very often, we have people saying "my lord" or "my lord." Now these are terms that are used sometimes in English courts, derived from British accents, which tend to join the words and say, instead of saying "my lord," you say "my lord." But there's absolutely no reason for us to be replicating it in India. So while some of the British customs that we follow are make eminent sense to me, uh, these things sometimes do not go down well uh, with, with people on the bench. They see it as pretentious. So please be aware. You have to come across as a genuine, earnest person. I think the key word here is you have to be earnest. And I'll talk a little more about this. Again, there has to be complete complete reverence for the bench. Uh, Remember, this comes out of the fact that uh, if you if you disrespect the bench, you cannot succeed in your profession because of the simple reason that your clients will also start picking up on that. It is certainly not done whether in court or outside court. You cannot disrespect. You may have your own personal opinions, but you have to keep it to yourself. You, any kind of impertinence is something that will gain you a very poor reputation. Now, in English folklore, I would say there was a very famous lawyer called F.E. Smith, and he came to be when he came to the bench, he was known as Lord Birkhead, and he used to be extremely impertinent, and but he carried it out with a lot of aplomb. Although if you read his biography, his biographer does say that there are many times when he had a narrative where he put in retorts in the court, which he may have thought about later. So it's not always, please do not try to ape it. It makes a very good reading, but I would certainly not recommend that anybody follows it, definitely not young lawyers. Uh, Respect for the bench is absolutely a prerequisite. Be very careful about your terminology. there is lordship and ladyship. If there are many judges on the bench, two bench or a three bench, you may address them collectively as my lords. Look the judge in the eye and look all of them in the eye. So sometimes if you have a three judge bench or sometimes even larger when you're before the Supreme Court, there is a tendency to look squarely at one or two of the senior judges. I think it's important to understand that you are addressing the bench as a whole. So be very generous in moving your gaze around. But if you're addressing a question that is asked, look into the eye of the judge who is asking the question. This is not just body language or semantics. These are, the various little things that help you to build the trust. And unless the bench trusts you as a counsel, you are not going to get very far in your career. Then another aspect that I've seen regretfully is that sometimes there is a tendency to criticize the judgment in appeal. So you're appealing against the judgment dished out by a subordinate court. And then there are terms such as, the honorable judge failed to apply his mind. The single judge did a singular disservice. This is, it's just not done, right? You could say the judge erred in not considering this fact, or the judge erred uh, in, in the manner in which this judgment would be placed before him was appreciated. But to use terms which are derogatory to say that the single judge failed to apply his mind, it doesn't do any credit to anyone. And I've seen sometimes judges get quite uh, quite angry when they read this kind of things. So, and then the other issue is you have to articulate. Now, what is articulation? One, of course, is the voice. But what is also very important is the tonal quality of the voice, the pitch. Whenever you speak, there will be certain words that you have to emphasize on. And that is something that, again, comes out of experience. But people who are good public speakers, or people sometimes are natural public speakers, will learn to articulate and pronounce words with the right tonal quality and emphasis. So nothing is worse than a courtroom where there are long arguments in a flat tone where somebody drones on and on. Now remember, there is no need to be loud. Articulation and tonal emphasis is not a function of the volume of the speaker. It is only the function of the emphasis that you place. So when you're placing emphasis on a particular word, doesn't mean you have to shout out that particular word. The other thing is never interrupt or talk over. I'm just very quickly running through these points, which may sound very basic to everyone, but as I read recently, many distinguished counsel, when they played their own recordings, were quite surprised to find that they were actually interrupting the judge. Never do that, right? And this happens because, remember, in court, you're focusing on a particular matter, and there's a natural tendency to talk quickly, to quickly make your point. You are under pressure. So these are the subconscious tendencies that come out, but you have to learn to control and do not interrupt or talk over the judge. The other thing is, sometimes there is this temptation to produce a judgment on the same point which has been rendered earlier by the same judge. It's a very tempting proposition. One thing is, always be aware that on this particular point, the bench that you are appearing before has passed this decision, but also be judicious in using it, because quite obviously, as everyone knows, judgments differ on facts, right? Can be distinguished. But more important, sometimes if you look at it from the perspective of the judge concerned, he does not like to be put into a corner and boxed in by somebody saying gleefully, see, you yourself have decided this. It may be a completely different context, a completely different case. It sometimes does not go well. So you should be aware, you may mention it in passing, or if it is squarely on the point, it's a different matter. All I'm saying is this should not just be a matter of routine course that you gleefully pull out. This is the decision of my lord made 2 years ago. It doesn't work. The other point is, and this is something that I learned the hard way, that many times the judge will get into a dialogue with either you or the opposing counsel. Now, sometimes in that dialogue, if you feel that the judge is in favor of your case, there is a temptation to again jump in and say, also, my lord, this is also the point. Again, the other counsel, your opposing counsel, who you have to respect, is answering. You cannot interrupt. You cannot interrupt the bench. You cannot interrupt the opposing counsel. Sometimes, incidentally, on this point of interrupting the opposing counsel, you may be sitting and watching the entire argument drifting into a direction which is really not really the point. I mean, it's not really even your case, right? And then you see that, okay, maybe I need to stand up and interrupt. On those occasions, you may do so. You may do so. You have to, this is again a question of judgment. But while doing so, always seek the permission of the bench. So you will stand up, first of all. Never talk to the bench sitting down. Stand up and say, may I have my lord's permission to make a small point? And you will either be told to sit down, in which case, please sit down immediately, or you may be told, okay, please tell us what you have to say. Right, but this is again extremely judiciously used only when you see that time is being consumed on a point which is a non-issue, which is not even your central case, and the only point you want to make is, my lord, this is not even the case that I have made. So why is this being argued? And at that time, you may be appreciated because the bench will appreciate that you are making a point which will prevent wastage of time. But otherwise, by and large, do not interrupt. Now, that brings us to the interesting question of what happens when you feel that the bench is against you, against your case, right? And this is again, it's a difficult scenario. But remember, now there are some people who pride themselves on being like dogs with a bone. I will not let go. Now remember that every time that you know that the opinion of the bench is contrary to you, to your case, and it may not be contrary to the overall case. It may be contrary to a particular aspect of your case, right? And every time that you pursue with that line of argument, you are expending your equity with the bench. And there is a limit to which that can go. So it's good to say that, you fight hard and you're tough. But perhaps it is a better strategy to understand whether, first of all, is it a very big point in the overall context? If on that particular argument, if you believe that the bench is against you on that particular point you have made, there are other points in the case. So first question is this something very material to your overall case? Yes or no? If it is, right, then the fallback cannot be that you repeat what you said because the judge has already disagreed with you. You cannot just keep repeating and insisting, right? In a different way, maybe. But then the better thing to do is to come up with another argument for the same point. So you may say, for example, that perhaps my lord may want to consider a particular case law which I may present before you, which supports the proposition. So again, you have to make a micro argument or a macro argument, but only if you feel it is the same point, because otherwise you will irritate the judge and you may lose. Sometimes there is a tendency to believe that, well, there is no case at all, right? Ultimately, you're only arguing 3 or 4 different points that completely holistically make up a case. And always, again, it's a question of judgment. When you know, suppose you believe that, okay, well, the bench is not in your favor, right? Now, remember, judges are very busy people. Their caseload, the workload is tremendous. Nobody really appreciates someone who's just keeping on and insisting on the same thing. So therefore, always have a fallback, right? One fallback could be, well, I will withdraw, right? Because, for example, in jurisdiction arguments, right, you made your point and the judge said, no, I don't believe that you're jurisdiction. So don't come to the High Court. This is an issue for NCLT, LAT, although, this point is by now, quite clearly defined. But previously, these jurisdictional issues did happen. Or for example, if you're arguing an arbitration matter in a court and you're trying to say this point is not arbitrable at all, right? There may be different points of view. But the point is, if you want to pull out, you can say, well, I will withdraw. My lord may say, that this does not mean that there is any adverse opinion on record on the merits of the case, because that helps you when you go to the other forum. Although it really shouldn't matter, because the other forum has to look at it independently. But then I think judges are quite happy to say that, yes, you were withdrawn and dismissed as withdrawn, and no adverse opinion has been offered. Further, always remember, if your main prayer doesn't work, there is an alternate prayer. You may not get your main prayer, but you may get something else. So there is always a fallback. Whenever you go into court, have your fallbacks in place. Now, does that mean that you are not a tough customer, that you are a weak fighter? Of course not. It means that you're just being judicious. And when to persist and when to give up is also a question which you should think about. But it's again something that comes out of experience. It comes out of a knowledge of the judge. What kind of a person, personality he is. Easy likely to get irritated if you keep persisting. So these are again sum total, and it's very hard to lay down a hard and fast rule, except to say, do not insist, but at the same time, you cannot just be a pushover. But if you're not a pushover, a guideline is it a major point that impacts your case? Does it change anything for you in the ultimate analysis? Number one. And number two, is there a different aspect that you can offer the bench? So for the same argument, you already made an argument, it's been rejected. No point persisting with that same logic. Maybe there's a different logic, or maybe there's a different case law. That may be a worthwhile situation to explore. But it doesn't really, benefit anybody to be like a dog with a bone. Courtroom humor. So we have all seen, instances of courtroom humor. One of the things is, so I have a quotation here for you, which I would like to read out. So there's this famous American case of Roe versus Wade. And Justice Kalia, who's unfortunately no more and who is my, one of my most favorite judges. I love reading his writings. Has a textbook where he says that Chief Justice Berger, who were listening to that matter in the Supreme Court, scowled because at the very beginning of that argument, the lawyer who was arguing, came up with this in a Texas drawl. He says, when a man argues against two beautiful ladies, they are going to have the last word. Now, he thought that maybe it's a light moment, a good opportunity to open the case and you know maybe break the ice. But the reaction from the bench was negative. It's not appropriate, right? So a lot of humor is sometimes inappropriate. So if you do want to use humor, use it very sparingly. And I can tell you that the best humor that you use has two features. One is that it is completely unscripted. Right? So you have to be a very witty person. If you do not fancy yourself as someone who's witty with repartee, do not risk it. It's better not to, right? So use your wit. Of course, it cannot be offensive. And the best bet is self-depreciating. So, I'm often told, that Parsis have the ability to laugh at themselves. I think that's a great characteristic, right? Everyone should be, you can't take yourself too seriously. Laugh at your own self. So, if you have something to say which is self-depreciating humor, there is zero risk, right? So therefore, that is the only time when you can use humor in court. Uh, there is, of course, a tendency to sometimes come up with, things which appear funny, but sometimes your sense of humor may not be the same as that of the bench or the others in court. Okay, now I'll turn to the second segment, which is the rules of ethics. Now, these are whatever I've discussed so far are generally thumb rules. They're not really rules, guidelines, but these rules of ethics are unimpeachable. You cannot ever uh, mislead the bench. You cannot ever, because remember, you are an officer of the court. The bench relies on counsels to assist them. I think everyone is aware of this. Everyone in court says this very often, that I'm an officer of the court and I am here to assist the bench in arriving at the right decision, right? But the arguments have to show this. Remember, to the judge, your word as a counsel should be bond. Very, very critical. So if, for example, you're giving a statement across the bar, you're giving an assurance across the bar, right? That assurance carries weight. And remember, you cannot do that unless you've been instructed by the client to say it, right? Sometimes you may want to, seek a little time to revert back to the court later in the day after speaking with your client, right? But any statement that is made across the bar, which is a declaration, my client will not do this, or we agree that this will not happen, uh, right? It has to be under instructions and taken very, very seriously. So now the difficulty is what happens when certain concessions are to be made, and I will address this topic a little later in more detail. But very often we read in judgments, which say the learned counsel very fairly admitted, right? And it's very good that there are counsels who will say, that this is something that I do not contest. I'm not assailing this particular aspect of this judgment. So you admit but admission is more in terms of facts, remember. And it's a good thing because you cannot defend the indefensible, right? But there is another angle to it also, which I will deal with separately when in the section on how to present your case. So again, in this rule of ethics, I just want to say one more thing. So in England, um, it is not considered to be ethical for a counsel or a lawyer to allege fraud. Fraud is a very serious allegation. It cannot be made lightly, and you have to have reasonably credible and arguable case of fraud. Of course, nobody can ultimately decide that there is definitely fraud and therefore I will argue it. But before you make that allegation against the other side, there has to be a credible and an arguable case of fraud. And this is very important because, very often, it's not considered to be, um, I mean, a lot of counsels do tend to say, well, he fraudulently, if you see some of the pleadings, this was sent fraudulently with a, it's something that we use very lightly, and it is not always a good thing to do. Then the other thing is never refuse to answer. Now, again, remember that there are two kinds of judges. There is one type of judge who will listen patiently to everything, record probably whatever you said. But as a counsel, I do not believe that's a good thing because somebody is listening and sometimes you cannot even make out what exactly the bench is thinking. Because I think it's better to have a judge who is interactive, who will ask questions. It sometimes can be very distracting, and I'll come to that aspect also. But it's better to have somebody who is interacting with you so that you know that this is something that needs to be addressed. Because you may make a long argument and come out without even knowing that a particular question that the judge has in his mind, or which he may think of when he reviews the case and writes his judgment, has not been addressed. It's better to address all doubts. So that's the other kind of uh, experience that you will have in courts. I think nowadays, probably because of the time pressure, I think courts are much more interactive, and I think that is a good thing. Arbitral tribunals, on the other hand, do allow uh, counsels uh, to have their say totally. But remember, in arbitration, what we call as chess clock arbitration, which means that in general, at least in international arbitration, both sides have equal amount of time, right? So uh, you have equal time, you have equal time. They listen to the case, and then there is a time that is set aside for questions to counsels. But in Indian courts, generally, I think the tendency now is that it is an interactive court, and we should not be worried or about that interaction, because that it is that interaction that tells you that there are certain weaknesses in your case, and you have to address those. So let me move on to the third section, which is preparation. Now, this may sound axiomatic. I mean, what is there that Mr. Billimoria is going to talk about preparation? It's a given that if I go into court, I will be prepared. Not really. I'll tell you why. Because sometimes, very often, what happens is that we believe, oh, it is an admission matter. So notice will be issued. At the most, it's a 5-minute argument. Now, this is wrong because And I've had instances in my career where you are number one, item number one, you argue for notice to be issued, and sometimes the judges don't want to leave the matter for later. Right? This is again a new trend. They want to hear you on at least two or three of the crucial aspects of the case, which typically may be much more than is required to just issue notice, because issue notice means let me hear the other side. But there is no hard and fast rule, and you cannot step into court without being completely prepared. That's just not doing justice to the matter. So from that perspective, always be prepared for any eventuality. Do not budget that this is just going to be a short argument. Now, the other question is, what exactly is preparation? Now, let me tell you that, in the UK, and I haven't had much experience of American courts, but at least in London, when somebody is doing a trial, remember a trial, okay, not appellate work, but when somebody is doing a trial, that counsel is just not available. He will not respond to emails, he will not respond to calls, because he is preparing for the matter. He is eating, sleeping, drinking, thinking all the time about his matter. Right? And this is real original side work, because some of these commercial briefs involve a lot of material. There are a lot of documents. Some of these have to be correlated. Even white collar kind of matters, the briefs are very, very heavy. And you have to be very familiar with the facts of the case, your strategy. So when you say that, I am prepared, what does that mean? It means that you have to know your facts backward. You cannot, because again, let's say you have an interactive session where the judge is asking you, but tell me about this particular aspect of your case. Now, you should be able to, in your mind, you have to be very quick on your feet. In your mind, you should be able to correlate immediately where that question is coming from, why it is being asked, what are the implications, and where it is in your brief. Now, the facts will be hidden somewhere in your brief. It may be for you or it may be against you, but you are being asked a question and you have to address it. If you do not address it, it comes across as being evasive. And that's absolutely a no-no. And to me, this is frankly the biggest challenge of being a counsel, which is no matter how well prepared you are, human memory is not, it does tend to fade over time, especially for people who are very busy. And I sometimes marvel at the fact that there are, so many counsels I know who have huge elephantine memories. But if you do not have that, you have to be overly prepared. You have to have your notes ready all the time. But one thing is, which you cannot do without memory, is something you can always make up for. It's very useful to have a great memory, but you cannot make up for a particular trait, which is presence of mind. You cannot freeze in front of the court, because if you're asked a question, you have to have the presence of mind. So you have to think very quickly. So there's a difference between thinking and remembering, right? The thought process, the logical thought process, the analytical process. This is the question. This is what I have argued. Where is this question coming from? What exactly is the point? Because remember, the bench is not obliged to tell you that this is my doubt. Sometimes they do, right? But it may just be a question of fact, and you have to correlate that fact to where exactly is this going, and what do I have in my brief which can respond to that. Again, you may have more than one or two things to say to that in response. Which is your best response? And that is extremely important. And to do that, you have to know the facts of the case backwards. Now, remember, um, as lawyers, we know, but it still bears mentioning that all facts are not necessarily true, because when you say, oh, it is a fact, in common parlance, we believe that, okay, that's the truth of the matter. But remember, all facts in a case is not the bare truth. In fact, it has to be proved. That's the process of the court. The common law system requires that your set of facts that you assert, those are averments that are made. You are making an assertion about a particular fact, and you have to submit evidence to show that is the proof that comes from the evidence. But there are some facts which can be refuted. So even evidence can be questioned, and then ultimately the judicial process is that the evidence is weighed, assigned a weight, and then the conclusion, the judicial conclusion by way of inference is arrived at. However, there are certain facts which are axiomatic, where it's but natural. I mean, sometimes you need not even state it as a fact. It's something which is presumed. So really, when you prepare your case, first question is, which are the relevant facts? And then which is the most material? And it's very important for you to have one sheet of paper which sets out the most material facts, and read that on the morning of the matter. Because material facts is what makes your case. Then again, one of the very useful aspects about preparation is that you have a timeline, a list of dates and events. Right? And I'm constantly surprised at the number of people who sometimes they prepare it, sometimes they just don't bother, but really, facts are just a bunch of propositions unless they are organized in the order of dates as they occurred. And see, the merit of that list of dates and events is this, that if you look at the facts in chronological order as they occurred, two things happen. Number one, you get the story. First, there was a board meeting, then this happened, so it's a chronological order. So it helps you to understand the story as it happened. Secondly, you may find a lot of gold nuggets of arguments where you may say, in his brief, my learned friend is saying this. But if you look at the timeline, what he's saying occurred much before this document was delivered. So how does he know this? Right? So these are gold nuggets of arguments that you will realize only when you study the list of dates and events in chronological order. There is no substitute for that. The other thing is you have to get into the mind of the other side. The one thing about lawyers is that you can appreciate the arguments of the other side, and it is only when you do that that you are able to counter it. Because if you do not know what the other side is going to argue, how does it work? Because you only know your case. And in fact, this is the other problem. Sometimes, the juniors do not pull out case law which are contra. It is very important for you to understand and know and be aware of the fact that, well, this is the case law that the other side is likely to come up with. And it's not hard to do, but sometimes there is no effort to even look at the contra. This is your case. Okay, great. But there are contra case laws. You have to deal with that. And even in the arguments, one of the very fundamental thumb rules that at least people are taught is, open with a positive case. right? So it has to be a positive case, not a defensive case where otherwise it appears negative. But open with the positive case. In the middle, you have a refutal. So if you are first, right? If you are for the claimant, for example, or the petitioner, this is your positive case. Then you have a very short module on my learned friend will argue this, but right. And now put yourself in the shoes of the learned friend, because if you have done your homework, you may have destroyed some of his argument before he's even started. Right? And the bench is immediately in, appreciating that. So you know that he will have a tough time making his positive case. So that's very, but that always comes in the middle, right? Positive case, refute, but very briefly, because otherwise you may get stopped at some point. And then again, end with a little more detail on your positive case. Remember, psychological studies show that people tend to remember. So when you see a movie, you tend to remember the beginning and the end. Right? If it's a long argument, what remains etched in memory is the beginning and the end. The middle sometimes is not as familiar or does not stay in memory for too long. So your positive case, beginning and the end in much more detail, but in the middle, use that little opportunity to come in and say, I told you my case. This is what he's going to say. See how, it doesn't make any sense. It's a very powerful tool. But to do that, you have to get into the mind of the other side. And you also have to have strategy. So, for example, recently I was doing a matter on IBC, and I was told that I'm for the creditor, and I was told that the company assets have all been dissipated. There's nothing left now, right? And they have appealed to the Supreme Court. Now I'm saying, why would they do that if they've taken everything away and the company is nothing? I mean, there are of course remedies under the law. We can explore that. But why would they then uh, resist the IBC, the insolvency process in the Supreme Court? And it's something that was at the back of my mind. And sure enough, before one could open one's mouth, the AOR on the other side came and said, we have no difficulty continuing with the IBC process as the learned NCLAT has decided. So point is the strategy, understand what makes the case of the other side tick. And it is only then that you'll be able to counter. And then again, you have to have a very commercial sense, right? This is a commercial sense, right? If you have already dissipated the assets as is alleged, right, by the client, then why are you contesting it? So that's a little commercial sense. It should strike you as something which is a little odd. Again, from the strategy point of view, in a trial, you should be able to prepare the case to an extent where it becomes like a game of chess, right? So there are certain arguments, and this is something that needs a lot of brooding, introspection. That is why I said that you eat, sleep, drink sometime, because these are huge matters, very, very critical, sometimes existential for the client, and you have to be top of the game. So even when you select what argument should I put, now an argument may look very nice to you, but then if you think further, you will know that, okay, if I say this, then the other side is going to counter it with this. Now suddenly my argument doesn't look that good. So unless I have a very good rebuttal to what the other side is going to use as a counter, maybe it's not a very big argument for me, right? Because remember, again, start with your positive case and start with your best point. 3 best points. Nowadays you don't get too much time before the courts, right? Which are the 3 best points, right? Start with the strongest, right? So arguments may look very good on paper, but in practice, do you know what the other side is going to say to counter it? It's probably in their brief, but sometimes it's also in their documents. It may not be stated so clearly. So you have to play counsel for the other side and then see what you can do to help your client by playing counsel. Now, this takes, an enormous amount of time and effort. And you see that sometimes we may not have, the luxury of that time. So therefore, there is another angle of preparation, which is how you do your research. And it is very, very important to have a very, very good, competent junior. So for example, as I mentioned that when the bench asks a question, you have to make sure that the reply comes to you in terms of what is the context in which this question is being asked, right? And very often, if you're well prepared, you will know that, yes, this is the correct answer. But now you have a big brief, right? It's a fat brief, right? So you know that there are these statements. Now, when you are before a court, you cannot sift through your brief, give me this volume, give me that volume. You have to know where that answer is. So therefore, it's extremely important to have notes where, because remember, a particular proposition may be on page 7 and it may be on page 77, right? And the two are linked, right? The same proposition are not in chronological order, right? In the briefs, your propositions are all over the place. Sometimes they're in the annexures. So you have to have on each proposition one sheet of paper, right? So again, be careful of being very dependent on your notes, because as I said, remember, you have to be prepared for a situation where you are thinking in a very syllogical, logistic manner, right? Syllogical is a very strong form of logic, right? Two propositions and conclusion, right? It's a very, very rigorous form of logic and a very powerful tool. So lawyers generally are very logical, right? So you say, this is X, this is Y, and therefore the conclusion follows, right? Of course, the conclusion has to follow from X and Y, right? But that's basically your competence. But when you have your notes prepared of your arguments, where it'll take you 2 hours to explain the whole case, and you feel that, okay, if I get these 2 hours, right, I'm going to succeed. Nothing can stop me. But the point is, you will not get those 2 hours. And the other point that you must remember is, while you are making that case, you may get stopped in the middle and say, but please tell me about this particular position, or what is your position on this? But see this particular fact that is in the brief. What do you have to say about that? So therefore, you may not get those 2 hours. So be careful about being so married to your notes. And this is again one of the weaknesses which I have corrected. In the early part of my career, this is what I used to do. I had very well prepared notes, but the moment I am interrupted, I get thrown off, right? And why do you get thrown off? Because you know that the question that is posed to you right now, you have the answer. If only you are given another 15 minutes, the answer will be very apparent, right? But you can't tell the bench that, please bear with me for 15 minutes, I will tell you, because that looks evasive, right? So therefore, do not be married to your notes, but at the same time, you have to be guided by your notes, unless you're blessed with a elephantine memory, which I'm not. So the way to make your notes is on one sheet for all. This is your proposition. Which are the pages of which volume where these propositions are found, right? And this is where your junior should be very able to assist you on this. right? So you can't answer and say, yes, I am aware. My answer is this. And then the judge said, please show me where it is in the brief. Right? And then you can't turn pages and give me that volume. No, I think that's chaotic. No, right? So you need to have a junior who is well versed with your style of arguing, well versed with the manner in which you make your notes, and who is following the argument so that he knows that this is the note you need, hands it over. That kind of assistance is very, very critical. Again, I I did mention that it's important to also look at contra case law. Very often, people quote head notes, you know, strict no. When you read the actual case law, you may actually realize that it is actually contrary to the facts of your own case. So the head notes and the ratio may appear attractive, but when you read the facts of the case, oh, this is the distinguishing factor. It sticks out like a sore thumb. But one of the techniques is what is known as syntopical research, and there is something that I think can be taught very easily. Syntopical research. So because again, I think lawyers is as a group, uh, we are quite used to sitting at our desk with about 3 to 4 different textbooks open, right? Because the answer is not in one textbook. There's no one chapter in a textbook which gives you the answer to the case. Every case is different. So what are you trying to do? You are trying to look at 3 different textbooks in your research. You're looking at manuals, culling out the proposition. Sometimes you're looking at the obiter to craft your arguments, right? To craft your proposition. So it's a vast ocean, right? So how do you know that you got this right? And I think there are some logical steps that are set out. One is that you have to define the issue very clearly, right? So people say, give me case laws on res judicata. Right? That's too broad. I mean, there may be so many, right? And it's not just case law. It's a doctrine. You have to read up on that. So that's too broad a definition. You have to define the issue that you want to research very narrowly, right? Because otherwise the junior is not going to appreciate what you're looking for. If he doesn't understand what you're looking for, he will find the wrong thing. So define it very carefully and specifically. Then you have to know what are the basic principles. So when you are researching something on res judicata, you know the basic principles, right? And then you have to zero in on the important authorities that are relevant to your case, right? Again, they may be contra or they may be in your favor. It's important to have contra also. But there may be many aspects, different aspects of that particular doctrine, which are not relevant to your case. Right? You may read them, you may scan them, but if you start reading each one cover to cover, it's going to take you, 3 to 4 days to prepare for each case. It doesn't work. So there is this method called syntopical research. I can, I can find some literature if people are interested and recommend that. But please do read this. The idea is to research so that you narrow down the authorities and the commentaries that you have to really study for your case to a manageable size. And then the other thing is, of course, something which I learned, with great difficulties, the ability to speed read. Right now, speed read is doesn't mean that you zoom through, because if you zoom through cover to cover, you will never be able to get to the bottom of the issue. So speed reading doesn't mean speed in reading. Speed reading means using techniques to appreciate what is being said. Right? And there are, again, techniques to do that. So there are certain keywords that you look for, or you may scan a paragraph first to see whether it is relevant. And if it is relevant, then read it again. right? But that you don't do that to every paragraph. So there are many other speed reading techniques. Now, these may all appear a little odd because how can you have these very objective rules to which help you in finding something that you are looking for? And the answer is that I found that it works. But again, it's an acquired skill. You can read upon it, but it's definitely an acquired skill. Try to do that. Another aspect is reports of the Law Commission. Now, again, as you know, laws are interpreted based on intent of Parliament. Now, there's nothing better than the origin of the law, where the Law Commission says this law is this particular section. What is so? For example, if you see the Income Tax Act, every budget there is always a notes on clauses that explains, right? So it explains what was the provision, why the change is needed, and what the change is about. Notes on clauses, right? So the Law Commission reports are very, very important. So, and then it helps you craft arguments. So, for example, there is this current controversy about whether emergency arbitrators are recognized in Indian law. And that comes from the fact that the 246 Law Commission had suggested that the law be amended to include a definition to say arbitrators includes emergency arbitrators. And that was not done when the actual amendment was incorporated. So there are two ways to look at it. It means that the Indian law does not recognize. Right? I think the better argument is that that change and amendment was not required because arbitrators include a tribunal, but ultimately, if you look at the generic definition of who is an arbitrator, it would include an emergency arbitrator. There is no need to do that because there is a principle of party autonomy, which is that whatever the parties have agreed upon prevails. Right? And if parties have agreed to have arbitration according to a set of rules, which include emergency arbitrator, then you have to go by those rules. Right? That's party autonomy. So the Indian law was not amended, I don't think is a very good position to take, because just because it was not amended should not mean that the intention of the legislature was to disregard emergency arbitrators. So again, this comes from understanding the Law Commission report. Now, you may want to argue either way, depending on which side you're on, right? And that's really one of the things about lawyers. We should have the ability to do that. But I'm just telling you this as an example. So now this becomes extremely important. So, for example, when you are looking at a domain area such as competition law, now, in competition law is developed over a long period of time, and there are certain most countries have competition policies that help interpret the law, right? We have not yet adopted a competition policy, but there are certain doctrines that are very well settled judicially internationally. So I don't think the right way to interpret competition law is to see, oh, there is a comma here and a full stop, and it's a proviso. Those are pure statutory interpretations which work, but they also have to fit into the larger theory of competition law, because it is an economic law at the end of the day, right? And it's based on certain economic fundamentals. And very often I found that, this is something that's hard to articulate. So, but you should be familiar with the doctrine, because at every point of time, whenever you are arguing a matter, the particular statutory provision is one, and then the underlying doctrine, which is not found in the statute, is something that can always be brought out in your arguments. So this is extremely, coming back to the question. So suppose you are asked the question. Now, first thing is that, I always hesitate to say, because the immediate reaction sometimes is, oh, that's a very good question, my lord. Now, I say, but who am I to say it's a very good question? It's a cut to the chase, right? You've been asked a question, address it, right? Or sometimes, you may say, oh, I'm glad you are asking this question, but really, who cares? Just answer the question, because sometimes this can come across or be interpreted as being patronizing. Right? The bench is entitled to ask you anything, and it is your duty to reply, but you have to address it squarely. Now, again, remember that just because a question is coming, it is not always a challenge to your case. The immediate presumption is, oh my God, he's not accepting my case and I'm being put on the mat. It's not, that's not the thing. Please. First of all, uh, if you see the question properly, it may be a rhetoric question, right? In which case, a member of the bench may actually be agreeing with you. He may be, so you are arguing, and then a rhetoric question comes your way that, don't you think that it should be this? Now, it may actually be something where he's saying that if, I was arguing this, this is what I will say, because that supports the point you are making, right? So all questions are not just, adversarial. Do not take it as an adversarial issue. The other thing is that maybe it's a genuine doubt that is in the mind. And, sometimes judges do tend to say that, okay, I understand your overall case, but this is the big issue for me, right? The questions come from there, that this is my big issue in this. Please answer this. If you don't answer it satisfactorily and you say, I will answer in a short while, or if it is just around the corner, you may say, if my lords will indulge me, I will come to it straight away, right? But by and large, it's not a good idea to do that, because it may come across as being evasive. And again, so remember that sometimes you quote the documents. Now, I have found very often that when you read a document, or a client or a briefing counsel gives you a document that is supposed to be in favor of your case, right? And it's a state of mind, right? Because if you read the words very carefully, it may not really be in your, because remember, these documents are just correspondences, right? So the executives of the company have been emailing each other, and nobody thinks in terms of the law or future litigation when these emails are crafted. Right? So sometimes if you are pointing to a particular document, you should always be clear that what you are pointing to is in fact supporting your case, because it can come back to you like a wet fish on your nose. But this is not what it says. Or many times, the bench will say, okay, read the full thing. Right. And this is the problem with reading extracts. So sometimes there is always the temptation to read a very good sentence or a paragraph, which is squarely in your favor, right? It's an extract. But then when it's an extract, be ready to also refer to and respond to everything else in that particular document or email or whatever it is, because that may be the other side of the story. And if you're not confronted by the bench, your counterpart will get up and say, this is what my friend said, but then please read the next paragraph, what it says. And then it looks like you've been checkmated. Right? So again, one of the skills is, you have to know, you have to plan your arguments. You have to know what to say. Right? Now, this is on record. You cannot escape it. Right? So by not articulating doesn't mean that you are avoiding it. So don't misunderstand that. Right? It is on record. You have to deal with it, but there are ways to deal with it. And one way to not deal with something is when it's an argument that can come back at you, and you are putting it forward as your argument, because then what happens is that you are pushed back. It's a psychological defeat. So even if you counter it later, the perception that is created is, there are two sides to this argument. So you have to be very judicious about selecting the argument. Again, as I said, the questions allow you to understand what the judge is thinking. It's always a better thing. In the earlier part of my career, when I had these copious notes, 2-hour arguments set out, and if I was able to make that argument, I would make the argument without consulting the notes. But who has the 2 hours, right? Because you run through that. Then it would have been fantastic. And you get flustered when you're stopped in the middle, right? So do not get flustered. And the way to not get flustered, two things. One is get used to it, be quick in your thinking. But the best remedy to that is you have to be so well prepared that you are ready for anything. That's really the key. So let's quickly move on to the next part, which is the rules of arguments, right? When you argue. So first we dealt with guidelines, how to prepare, right? And some of this I would have already probably touched upon. Now remember, what is an argument? You are not crossing swords, right? The word argument is sometimes a misnomer, right? Argument is advocacy. Advocacy is the art of persuasion, right? Sometimes nowadays it can also be a science, but remember it's also something that you imbibe as an art. It's how do you persuade your audience, which really means what to say. I think, as I just dealt with what to say, when to say and how to say, right? How to say we dealt with in the first part, modulation, voice modulation. There's a very fantastic essay that somebody wrote incidentally on the power of the pause, right? So some of the best counsels are orators, right? And oratory, like comedy, is all about timing, right? And sometimes you have to pause and you have to be very mindful of the bench. Is the judge following your argument? What is the body language, right? So, and if you feel that there is no you are disconnected, then that's when you are in trouble, right? Because you have to keep everybody engaged, right? So you have to be brief, you have to be pertinent, relevant, without overly dramatizing the whole thing. And your voice cannot be a flat tone, right? And that is all about the art of persuasion. Now, the point is that another very important aspect is that you have to tell a compelling story. Now, when I use the word story, I don't mean, it can't be a fairy tale, right? So when I say story, don't take it in the sense of some kind of a fiction story. But ultimately, please remember, you are dealing with historical events and facts, right? And there may be a lot of material, there are a lot of facts, a lot of micro events. But what is the big picture story? This is the key, right? Ultimately, this is what happened. Ultimately, I supplied the material, right? And there was a penalty for delay. I was happy to pay that penalty, but I was still not paid the full amount. In a nutshell, what is your story? And it has to be a compelling story. Now, in arbitrations, this is a big help because you have in international arbitrations, you have what we call as opening arguments, right? So it's a skeletal. This is the skeletal of my case, right? So you are not actually making the arguments. You are setting out your propositions or your story. This is my case. And then when you come to the arguments and the evidence, then you have the little bits and pieces of meat that you fit into the skeleton. So your jigsaw puzzle becomes complete, right? Now, in courts, we don't have that luxury of opening arguments and things like that. But it's sometimes depending on the forum, depending on the, whether it's an interim matter, final arguments, it's always a good idea to start your argument with a very concise overview of what you're going to say, because it gives everybody the big picture. This is my case, my story. Now, of course, you can't say story. So there is a notion called quote unquote case theory. Now, I think criminal lawyers will know this, that what is your case theory? So case theory means that there are circumstances which can be explained as story A or story B. Story B is guilty, story A is not guilty, right? So to take a very simple example, if you are for a defendant, right, in a murder trial, say, right, the case theory is I was there in the room, right, but then I went away and then I came back later. Now, in between that period, somebody entered that room from the window. That's your case theory. And the prosecution will refute that. Right? But that's your main plank. So always have a case theory. And, as I said, in criminal law, people do this, but even for commercial matters, I think it is very important to have that case theory at the back of your mind, because if all the facts that you have in your brief add up to a credible case theory, remember, if you're stopped in the middle of your argument and asked a question, right, you have something at the back of your mind to relate to, right? It is like a roadmap. It's a roadmap which you already have, where you can relate to that question in terms of, how does that question relate to that skeletal case theory or skeletal argument that you have. And that's a very good way to immediately understand where this question is coming from and what should be the right answer. Right? And in a final argument, you can always repeat it in very, very briefly, even though it's not an opening argument or closing argument kind of model. But it gives the overview, and then you can start going into the levels of detail. Of course, I said earlier that you have to understand the case of the other side very well. But there's a small trap there. And again, I'm speaking from experience, right? So there have been times when I've actually understood the case so well that, I say, oh, he's right. Okay, but remember, your duty is to speak for your client, right? And you have to be completely convinced about the case. You have to speak with conviction, and it can't be a pretense, right? You may be a very good actor, right? But the point is, it comes out at some point or the other, right? You have to have the conviction in your case, having understood. So I just want to read for you a particular quote that I have actually, this is my diary, and I have written this quote. I don't know who has said this actually, but it's on the first page of my diary. Studying my brief at night because I am driven to understanding both sides of the argument so thoroughly that I could argue your side for you and win, even after having just handed you a resounding defeat. Okay, it's a beautiful quote, right? And this is really, so understand both sides so that you can argue either at any point of time, right? But ultimately, the problem with that is that, sometimes if the other side says an argument and you are thinking to yourself, yeah, he's right, because it's human nature. So you have to also understand that your arguments have to be completely convicting. Not just it's not just about having courage of convictions. You have to believe in your case. That's the point. Again, we have this term in apart from final arguments, where of course you start with your strongest case and then move on. In shorter hearings, the question is, what is the nub of the green? Right? In very simple words, this is what happened. Not in legalistic. The nub of the green is, my lord, this is the injustice, and this is. And remember, I mean, judges read their briefs, right? They form opinion. Sometimes they may not read everything, right? So, everyone is very familiar with, admission, and, during mentioning, it may get, your file may be thrown out in 10 seconds, right? So you should always have one key thing to say in 2 sentences. One key thing, which is really the shocker, right? I mean, if your case, it depends on your case, right? I mean, if your case is ordinary, doesn't deserve to be admitted, it's a different matter. You can't invent. Ultimately, you have to go by your brief. But in many big cases, remember, commercial litigation, businessmen don't like to litigate unless there are strong grounds to feel that there is something here where they have been wronged. Okay, so you have to have, and it can't just be a feeling of injustice, right? It has to relate to the law. So what is your one big point here, right? One big issue where you'll say, but lordship, in this matter, this is the issue. And you have to say it in 2 or 3 sentences, otherwise you will not get the time. So what is the nub of the green? If you see some of the seniors arguing in Supreme Court, they have the ability to summarize a huge brief in very short, very simple terms. A, because of paucity of time, and B, because this is really, I mean, they have the pulse, right? I mean, they know that this is what will work, that this is the big shocker. So always have that at the back of your mind. Then, of course, the other thing which I mentioned, I'll just mention again in passing, is understand the forum, right? If you are doing final arguments or an interim, asking for interim relief, right? The writ. Again, there are certain, what should I say, certain trends. Okay? So, for example, now Arbitration Act is amended. So, in a Section 9 proceeding, it's now pretty common for judges to say, okay, I'll give you that interim relief, but now, appoint the arbitral tribunal, and under Section 17, the tribunal will then take it up. Right? I mean, previously Section 9, arguments were fairly exhaustive, right? And sometimes one felt that, you are exhausting the entire dispute in the preliminary Section 9 application, what remains. And of course, you will not get that relief because that's a final relief. But now the trend is that, so now the tribunal can pass an interim order under Section 17. So until the tribunal is formed, I will protect you, right? Provided, of course, you convince the bench that there is reason for such protection. There is a genuine apprehension on your part that the entire substance of the arbitration will dissipate if you are not immediately protected, but it is only till the tribunal hears the matter. So this is a new development. It used to happen previously, but now with the amendment in the law, it's very clear. So there are these trends, like, sometimes, so you have to understand, which way these, courtroom trends are developing, what is generally a serious issue, what is not a serious issue, what you can ask for. You can't ask for the moon. It has to be rational, correct? Secondly, the other thing you have to understand is whether to cite your authorities in detail or not. Now, that's always a very important question that you have to plan for in advance. you know, so sometimes there is one single authority that makes or breaks your case. Right? I remember, in an NCLT matter, um, we had filed a petition, and then the Supreme Court came up with SR, and that was squarely on that point. Right? And after the petition is filed, and the bench said, but now SR is there, right? And so I was prepared enough to say that, but SR does not address these two issues. And in fact, I am in tune with what the SR decision says. Right? But that was the first thing that came out. Right? But isn't SR now decided this point? Right? And in fact, SR had clarified a lot of that. But of course, as a counsel, you have to distinguish. Right? So that was one matter where one had to constantly refer to, and it's a large judgment, it's several pages, and one had to constantly refer to that judgment. So it was really the pivotal judgment that decided that case. Now there are many matters where there is no one single pivotal decision. There are many other authorities, precedents on the same proposition of law, right? Facts may be different. So don't fall into the trap of discussing each one of those in detail. You may mark 2 or 3 paras of that. Inevitably, in final arguments, it's always a good idea to give what is known as a convenience compilation. Right? Sometimes the benches also ask for that, which enables in that compilation the major authorities that you are relying on. And you can refer to 2 or 3 paras in that. Or if you believe that there is a fact there that probably distinguishes the authority you're presenting, deal with it. Never be afraid of weaknesses in your case, by the way. You have to deal with it. The other important aspect is it's always a good idea to request for some time to furnish written submissions. Right? And see, what happens is inevitably, as you argue a case, a lot of what you have in the pleadings evolves because you heard the other side's arguments. There are aspects that the other side has raised, the aspects that you have addressed during the course of your arguments. It's not uncommon, and this happens even in arbitrations, by the way. It's not uncommon to find that what you have actually argued, is quite different from the pleadings. So it's always a good idea to summarize all of this in written submission, but written submission have to be very razor sharp and focused. Right? And the good counsel will always ensure that when you are arguing and you get to know these were the question marks in the minds of the bench. These were the 2 or 3 points that the bench was really concerned with. They were repeatedly coming back to this issue. Right? Written submissions is an opportunity to reiterate your answers to that. Again, not a good idea to put in written submission what you're not actually argued. Okay, what is written submissions? It's really a summary of what you have argued. Right? And sometimes there's a tendency to slip in something more, may not get appreciated. Why do that? Right? I think restrict it to what you have argued, but specifically address those points which you believe concerns the bench. And it's always a good idea to have very succinct, short, razor sharp. In fact, many times you're asked how many pages. So, you have to say 3, my lord, or if you say about 10 pages, no, make it 3. So these are the kind of thing, because judges, do not have time to go through reams and reams of paper. I mean, they are overloaded. So you have to assist the bench in every way, including making, their reading, the task of reading easier. it can't be that you, anyway, then I think there's just, I think we are ready for the questions. I see the chat function coming on to say. And I think I've covered all that I had to say. So, let's see what questions people have.
Professor Ravanli, we have some live question requests. With your permission, can I bring them live, sir?
Absolutely.
Thank you so much. So, Amit Ghoshal, please unmute yourself and ask a question live.
Yeah, good afternoon, sir. I hope I'm audible.
Yes, you are.
Yeah, so yeah, good afternoon, sir. Thanks a lot. It has been a really wonderful experience hearing what you have briefly tried to encapsulate all the experience that you would have had in all these years in the courts and as well as in your chamber, and it's really insightful. Now, I have a particular question, and it is relating to the discussion that you had about how trials are prepared in UK and how an advocate or a counsel goes knee deep or neck deep into the waters and tries to understand the facts. Now, I mean, I personally feel that in India, for whatever reasons, the practice in litigation sometimes becomes a T20 match as opposed to being a test match where 5 days is played out. It sometimes becomes a very short form game. And because of the number of cases that even an individual young lawyer or even an experienced senior advocate has to handle, it becomes too much of work and too little time left to devote to these cases. Now, it's my personal question. I want to know what do you do when you are faced with a situation? Have you said no to a brief, or you have tried to use your time in the best possible way, in the sense prepare the best notes and devote 40 or 45 minutes to preparing the brief? What do you do?
Okay. First of all, you see, a large number of cases that you do in courts will be fairly routine. Which will not have, I think, I'm really talking about when I say trials, right? In the Indian context, you should consider, the very large matters which will probably set precedent, right? And for those kind of matters, I don't think you have a choice. You have to be very well prepared, and to that extent. And I think it's a good practice that when you are involved in a matter like that, you do not uh, allow yourself to get diverted. It's a very difficult task. Family commitments, etc. And there's also the temptation to say, there's this other small case, wo bhi kar lete hai. But I think you are doing a disservice to, if you have a huge matter of enormous significance, you should focus on that matter. Again, here we are considerably assisted by the fact that over there, when you say trial, they last, start to finish, right? The scheduling is, it's not that there will be a hearing today and then there will be a next date that is given. That here, no matter how significant the matter is, that's what happens. So that is actually something that can assist you, because when you take on the brief, you should be very thoroughly prepared for that. So if the matter comes up very suddenly, with a day's preparation, you are ready to plunge into it. But it is not the same thing as a trial where right from opening arguments to closing, evidence in between, it's, stretches over a period of 2 weeks, and then that's it. Because then that's very intense in terms of, because it's one thing to commit totally to a matter for 2 days. One day entirely preparation, and the other day you have final argument, say. And it's quite another to say, I'm not going to do anything else for 2 weeks, and another week prior to that for preparation, because that's 3 weeks off. So these are very different circumstances. But I think one has to be very judicious, and there are certain tools to manage this little dilemma that I mentioned. In terms of the way research is done, and the quality of the people who are assisting you. Yes, next.
Thank you, sir. Mr. Abhishek Kaushik, please unmute yourself and ask a question live.
Hi, am I audible?
Yes.
First of all, thank you very much, sir, for this patient and erudite lecture on art of advocacy. But I must also thank Mayuri for having convinced you to deliver a lecture on a Friday afternoon for us, and at the lunchtime as well. So it is very thankful to Mayuri, and thank you, sir, for this lecture. Now, my question is, which is in the common parlance happening day to day. What happens is when we go through the book Before Memory Fades, Fali writes, one of the things a counsel should not do is giving media interviews in an ongoing case where he is appearing. Well, we see that being breached day in and day out. My question is on that opinion. What's your opinion on that? And second, sir, is a question which we wanted to know that, practicing in Supreme Court, the brief gets thrown out in seconds, matter of minutes. It's easier to convince the judge. How to convince the client back home that, look here, your case, the judge had read the case. But, it's easier to explain it to the judge than to the client that your case was actually considered, because his brief has been taken up for 30 seconds and put down, whether notice was issued and an interim order was passed. But how to convince? That's the two questions that I had in mind. I wanted you to reflect. Thank you.
Okay. So very, very good question. So on the first one, absolutely, when you're involved in a matter, you can't, speak. You can't speak to the media. It should not. It's not correct, because see, nowadays, when again I have my own personal view on this. Nowadays, the media also is not really what it used to be, and we've got to be very careful about that. And I don't think it's a good idea to answer any question when you are, on either side of the argument in court. You can do so after the judgment is pronounced, but not before that. On the other question, so I think one of the main characteristics of a counsel is the ability to manage a client, right? And the way to do that is by being very, very honest with the client on his chances. I think, if you avoid the temptation of saying that, oh, this is fine, always explain to the client the weaknesses of the case. Always explain the weaknesses of the case, right? And having done that, I don't think it's an issue. I think most mature clients, especially in commercial matters, understand that this is a risk that you take. I'll tell you what the clients do not appreciate is if they believe that you are not well prepared, or many times they sit in the court, and nowadays, of course, that's not possible. But many times clients fly down to sit on the last bench and see the argument, because these matters are very important to them in their business. And what they don't appreciate is that if you miss the trick, right? And again, when the clients are briefing you, they will always say something, sometimes very passionately, but then you have to tell them, listen, I understand what you're saying, but it's not a legal argument. I mean, what you're saying is not correct. Right? So you have to be honest with your client, just like doctors. Right? Can you imagine the difficulty a doctor has in telling someone that you're going to live only for 2 months? Right? Think of that.
Thank you,
Next.
sir. Abhijit Chaudhary, please unmute yourself and ask a question live.
Good afternoon, sir. Am I audible?
Yes.
Good afternoon, sir. Firstly, I'd like to thank you for this wonderful, enriching webinar and all those tips on advocacy. So my name is Abhijit Chaudhary. I'm in third year, pursuing BBA LLB from Symbiosis Law School, NOIDA. So my question is that when I, for example, for instance, when I'm appearing in court for the first time, I'm arguing a case for the first time, I don't know the judge. I don't know his mindset, his psyche. So is it very important to understand that also while arguing, and how do I achieve that?
Absolutely. I mean, you have to have done your research on the job. So I mentioned earlier that, depending on the, there may be decisions of that particular court, not just that particular bench, that, the judge may cite and say, but, Abhijit, but, this court has already held on this point in this matter. Right. So you have to know what is the thinking, and the, like I said, the trend, right? If it is a rate, you better be prepared properly, right? So research and knowledge is very much a part. Another tip I can give you is it's always a good idea, time permitting, to go in and sit before your matter is called out, because you observe what is going on in court, how things are going. Sometimes I found that just the matter before mine is called out, a judge gets very angry or agitated about something. I say, oh my God, bad news. But it's good to be forearmed, and to understand what is happening, rather than to have it take you by surprise.
Thank you, sir. So we have a couple of questions in the Q&A box. If it is, if you may permit, may I place them before you, sir?
Please do.
Thank you, sir. So this first question is from Ms. Righanka Basu. She says, as you have said that when the opposing counsel is having a conversation with the bench, would raising objections to arguments of the opposite counsel be considered derogatory in that sense?
Answer is, I don't think derogatory is the right word. I think it's, in a way, disrespect. It's just not done. You cannot interrupt. See, when you are arguing, you do not want, your opposing counsel to interrupt you, right? And you should not do the same. It's just courtesy.
So the next question is by Ms. Priyanshi Rastogi. She says that people generally remember the best, what is said first and last. Similarly, psychological studies suggest that what is said more often is also more impactful. Could this aspect also be used in structuring the arguments or written submissions, or would such repetition be frowned upon by the bench?
It depends if you're keeping on harping on the same issue. So okay, so this is a very good question actually, and let me answer it this way. So you are repeating the same point, right? But try to reiterate on different grounds, right? So you made a point which you think is crucial, that this is my central case, right? And then there are various reasons why you are saying that. So the grounds. So again, remember, what is a syllogism? It's logic, right? So there are two propositions that lead to a conclusion. You said that. The next time you repeat it, you can't repeat the same thing because that's repetition and it will cause irritation. But you have to then, so there is another case law. A case law that reiterates the same point. And then when you're reading it out, you can draw attention and say, as my lordship knows, I had mentioned earlier that this is my main case and this case law is central to that issue. I may be permitted to read a key paragraph, right? So while reading that case law, you have reiterated. So there are different ways of reiterating. reiteration doesn't mean repeating the same thing again and again. Otherwise, you will get thrown out.
Thank you, sir. Ms. Mayuri, I have a live question request, if you may please permit. Mr. Shivansh Tiwari, please unmute yourself and ask a question.
Yes, sir. Sir, am I audible?
Yes, please.
Yes, sir. So first of all, thank you so much for the session. It was a pleasure hearing from you. I'm a third year learner from Symbiosis Law School, NOIDA, and I'm also part of the mooting contention. So one of the difficulties we are facing in the midst of a pandemic is like we are having most of our moots like virtually. So since this is a session based on advocacy and psychology, I wanted to ask if there's any difference in preparing for a virtual hearing, since we can't exactly assess what the opposition or the judges in front of us are thinking. Because in a physical hearing, we do like we can assess from their body language or anything whether they are accepting our arguments or not. In a virtual session, that's like pretty difficult. So what are your opinions on that?
So first of all, I don't think this is a barrier to understanding the case of your opponent, right? Because you have their pleadings and all the documents they're placed on record. So I don't think that is a problem. You must do that. But you are right that sometimes physical presence, and I'm a firm believer that online hearings can only go so far, and there's no substitute for FaceTime, to put it to use the old cliche. So let's talk about the counterparty to start with. The counterparty, sometimes you do have that thrill that you said something, and there's a scurry of activity. There's a big legal team, and everyone is flustered. Get this, get that. You know that you caused you won't get that in a physical hearing, in a online hearing. But by and large, you can understand their case, and the counsel is there before you. You have to follow some of the subtle hints. As far as the bench is concerned, it's a big problem, because you don't, like I said, one of the key things about advocacy is understanding what the bench is thinking. There are body language. There are still the questions that come to you, which can be pointers, right? See, human beings are very perceptive. I think we'll adapt to that. Even without body language, we'll pick that up. But there's no substitute for physical hearings in court, because you cannot really have advocacy in the true sense without physical. I mean, the correct, when you say advocacy in the true sense, in the traditional sense, it's in court. There's no substitute for it. But we don't have a choice. We have to adapt, right? So there are the pointers that you can pick up.
Thank you, Mr. Percy. Seeking your permission, Mr. Percy, for another live question.
Of course.
I know we're over time, but I hence seek your permission.
Sure.
Mr. Abhishek Kaushik, please unmute yourself and ask your question live.
Thanks for answering that first question. I was muted, so I could not thank. Now, this is a follow-up of what the learner had just asked about the virtual hearing. I remember in the book of Fali again, in the chapter Lessons in the School of Hard Knocks, the very last proposition was, he gives an example which Sir Jamshedji Kanga had told a story about a counsel who could not hear a judge and was to make sit next to the judge so that he could hear the judge whisper as to what they were talking. But in this virtual hearing, when actually the judges mute their mics and we are not able to hear what they are discussing so as to understand the mind of judge. So in that context, I am saying this learner's question could, has a point in that context.
So let me tell you, you are not supposed to hear what the judges are saying to each other.
I know what. This is what Fali says, art of advocacy. We must actually address what the judges think.
It is not even a good idea to stare and try to strain your ear, because you're not supposed to hear. They are and the bench is consulting each other. They're brother judges, right? So it's not done. I mean, sometimes something will fall on your ears, but it's not a good thing to do. But I think the problem is more not in hearing what they are whispering, but it's also in the dynamic, there's an indefinable energy in court, right, which you cannot replicate in a virtual hearing. So I mean, someone mentioned about Friday afternoon, right? I'm sitting in my my chamber at home, right, which is fortunately good enough to do this, but at the same time it's not the same thing as being in court. It's a problem, but we have to adapt. We don't have a choice.
Thank you very much.
Thank you, Mr. Percy. Ms. Mayuri and Professor Avandle, I don't have any more live question requests as of now. I request you to take forth as far as the closure is concerned.
Thank you, sir. Sir, thank you very much for such an enlightening session. May I please request now Professor Dr. Avandle, sir, to come and give a vote of thanks.
Before I begin, like your earlier sessions, and this is another phenomenal session which you just delivered, Mr. Percy. And what you informed us, well, art of advocacy, but you told us about what is so prevalent and which we may have forgotten and which we need to go back and see, because you have had your session in different compartments, but I tried to make them in my own way. The first thing which you said, that a professional needs to understand his or her own world, where they are, how they would do the things, how they should handle the things. And if they do not know themselves, forget about them knowing the other side as well. And you said it in that way, that one should know the world they are in. Second point, which you made it very clear, that do not forget the common sense, because common sense is the key. Because all the points which you made, you said that it is in the common knowledge, but it should make sense to you as well, so that you follow it and you present yourself that you are part of this noblest profession. Third thing, most appropriate, that the presence of mind. But yes, one needs to distinguish between theatrics, drama, than argument, because end of the day it is we stating, not just arguing. Fourth was rather the most, that you need to cite in your own, but in a convincing way. It should make sense, first to yourself and then to the opponent and thus to the bench. And the last, which I consider the most one, was that do not leave the humbleness, because humbleness makes you worthy of this noble profession. And these are 5 virtues which I could learn. Of course, people may find this is there. And one thing which you said about research, I like that the most, because today we feel that the availability of resources in the form of databases. So people feel that let me just type it, let me just read the head, and let me just cite it without understanding. So when you say read the thing in detail and then call out the points which are applicable, otherwise you will be caught off guard, and you, instead of arguing your own matter, you would be arguing the matter for the other side. And that's what experience informs you, and that's what comes from you, and it really. And yes, most importantly, you further said that we have the ability to read. We should utilize that ability to read as well, not read only the books or the arguments of the other party, not only the mind, but how it is going, how it is suitable. And when you cite it, like one needs to focus on the law commission reports as well. Means what was that which led to the requirement of this change or amendment or alteration? And yes, because I remember this was the lesson which was given to us by our teacher who taught us constitutional law back in your law school days. He said, if you need to know the law of this country, you need to first go through the Constitutional Assembly debates. If you go through those debates, you will find the responses or adequate responses for the laws then made and operational today as well, or have been made unoperational. So that makes the sense that it is not law which is argued before the court or before the bench, but law is made at different places. So we need to relate with that, because law cannot be studied in isolation. You need to leave the law. And that's what you were informing through your talk. And as usual, you said it, you did it in a way which you are known for. Thank you very much, sir. You always have been very kind. I would like to inform the August gathering that sir not only accepted, but sir has been honorary faculty, and it is he who always rather comes with one or the other topic and shows his willingness that I would like to cover. I would like to cover this topic, and then next time this. We look forward to your next session soon, sir, and I'll come back to you. And
Thank
we
you.
will have the sessions for all of you. Thank you very much. Thank you very much, Mayuri ma'am, and thank you very much
Thank
to
you, everybody, for being here. Thank you.
yes, and to the audience. Thank you very much. Have a nice day.
Thank you so much, Mr. Percy, on behalf of Lex Witness. Let me compliment you without doubt that it's been 10 years that we've been a monthly magazine in the industry, and we would have done about hundreds of events.
Mm.
But I don't have any hesitation in saying, sir, you're one of the best that I've ever heard to. And I really go back to my team members and ask them as to why did we not find this gem earlier. We will definitely come back to you for your great speaking once again in our forums going forward, sir. Thank you so much for everything.
Thank you very much for saying that.
Thank you, sir. Thank you.
Bye-bye.
Bye-bye.
Professor Ravanle, seeking your permission now to end the webinar.
Yes, Mr. Akshay. Thank you.
Thank you so much, Ms. Mayuri.
Thank you, Akshaji.